Specifically, the two presidential candidates, that is, the People's Democratic Party, Alhaji Atiku Abubakar, and that of Labour Party, Mr. Peter Obi, argued that the lower court erred in a judgment because President Tinubu did not get at least 25% of votes cast in the Federal Capital Territory, Abuja, adding that the Independent National Electoral Commission, INEC, deliberately refused to transmit the results of the poll electronically to its portal in accordance with its guidelines. Whereas Atiku, through his legal teams that comprise 18 senior advocates of Nigeria led by Chief Chris Uche, SAN, filed 35 grounds of appeal to challenge Tinubu's victory. Obi, through his own team of lawyers led by Dr. Levi Ozoku, SAN, filed 51 grounds of appeal before the Apex Court. INEC had affirmed Tinubu of the ruling All Progressives Congress APC as the winner of the February 25 presidential election. In his own appeal, Obi, who came third in the presidential poll, maintained that the Presidential Election Petitions Court panel erred in law and thereby reached a wrong conclusion when it dismissed his petition. He alleged that the panel wrongly evaluated the proof of evidence he adduced before it and occasioned a grave miscarriage of justice when it had that it did not specify polling units where irregularities occurred during the election. Mr. Obi and the Labour Party further faulted the Presidential Election Petitions Court for dismissing their case on the premise that they did not specify the figures of votes or scores that were allegedly suppressed or inflated in alleged favor of President Tinubu and the APC. They equally accused the Justice Sanami-led panel of erring in law when it relied on paragraphs 41D2 and 54 of the first schedule to the Electoral Act 2022 to strike out paragraphs of the petition. While accusing the lower court of breaching his right to a fair hearing, Obi insisted that evidence of his witnesses was wrongly dismissed as incompetent. He told the Apex Court that the panel unjustly dismissed his allegation that INEC uploaded 18,088 blood results on its portal. More so, Mr. Obi alleged that the lower court ignored his allegation that certified true copies of documents that INEC issued to his legal team comprised of 8,128 blood results that contains blanked A4 papers, pictures and images of unknown persons, purporting the same to be the certified true copy of polling unit results of the presidential election. He said it was wrong for the lower court to dismiss his contention that INEC bypassed its own regulations when it refused to electronically transmit results of election from polling units to its portal. The appellant stated that the panel wrongfully dismissed the issue of double nomination that was raised against Tinubu's vice president, Senator Kashim Shettima. On his part, the presidential candidate of the People's Democratic Party, Alhaji Atiku Abubakar, in its appeal, maintained that the verdict of the Justice Haruna Sanami-led 5-member panel of the Court of Appeal, which had on September 6 dismissed his petition against the outcome of the presidential election, was not only against the weight of evidence, but occasioned a grave miscarriage of justice against him. The former vice president insisted that the Presidential Election Petitions Court panel erred in law when it failed to nullify the presidential election on the grounds of non-compliance with Electoral Act 2022, even when evidence that was adduced before it showed that the Independent National Electoral Commission acted in breach of extant laws and regulations guiding the conduct of election. He accused the Presidential Election Petitions Court of reaching its unanimous decision based on gross misconduct and misrepresentation of provisions of both the 1999 Constitution as amended and the Electoral Act 2022. He argued that Section 64(4) and 5 of the Electoral Act, as well as INEC's regulation and guidelines for the conduct of the election, which he tendered in evidence, made mandatory the use of the Bio-Voter Accreditation System BVAS machine for electronic transmission of results of the election directly from the polling unit to INEC's collation center for the verification, confirmation, and collation of results before announcement. Atiku told the Apex Court that some of the presiding officers who personally handled the Bio-Voter Accreditation System machines at polling units on the election day had, in their testimony before the Presidential Election Petitions Court, confirmed the non-transmission of results of the presidential election electronically from the BVAS machine, whereas results of the National Assembly election that held simultaneously were electronically transmitted without difficulty. More so, he told the court that INEC sole witness Lawrence Bayode admitted that the commission experienced a technical glitch that made the system to fail to work on the day of the election, which technical glitch was not explained by the first respondent. Besides, he argued that by virtue of Section 1691 of the Constitution and Section 148 of the Electoral Act, the INEC regulations and guidelines had the force of law, being a direct product of the Constitution itself. Thus, qualifying as subsidiary legislation. Atiku told the Apex Court that the non-compliance with the Electoral Act was nationwide, cutting across 176,846 polling units in the country, and a situation he says substantially affected the outcome of the election. He said the outcome of the election ought to have been cancelled based on the doctrine of legitimate expectation. Atiku Abubakar maintained that FCT Abuja cannot be construed as the 37th state of Nigeria as done by the court in the light of the clear provisions of Section 2.2 and Section 3.1 of the 1999 Constitution. He therefore prayed the Supreme Court to, among other things, hold that Tinubu was not duly elected by majority of lawful votes cast in the election, and also declared that he was not qualified to be declared the winner. Aside from praying the court to declare him as the authentic winner of the election and order his swearing in as president, Atiku, in the alternative, urged the court to order a runoff between him and Tinubu, or to nullify the entire poll and order INEC to conduct a fresh one. Cited as respondents in the appeal were INEC, Tinubu, and the APC. Best Orator, reporting for BTV News.